Good morning. You may be seated. We are here this morning on our case number 1 CV150844FC, Susan Doty Perez versus Tonya Doty Perez. We welcome Judge Gertler with us this morning, who's sitting pro tem while we are down a judge on this court. Not for long, though. That's good. Counsel, as you know, each side's allotted 20 minutes for your argument. The appellant may reserve any amount of time you'd like to use in rebuttal. If you do decide to reserve time, you're in charge, though, of keeping track of it by yourself. The clock on the podium will reflect the total amount of time you have remaining, including what you might have decided to reserve. We record these proceedings, so when you approach the podium and for the appellant each time, we'd be grateful to you if you would identify yourself and your client. We have read the briefs and studied the record. We've also discussed the case in our conference. So with that, you may proceed.
Good morning. May it please the court, my name is Marcus Reisinger. I'm here with co-counsel Leslie Satterley. We represent the petitioner in the court below and the appellant in this court, Susan Perez. We're here today to discuss the parent-child relationship between Susan Perez and the children that she and Tonya Doty adopted during their marriage. Susan is the children's mother in every meaningful way to the children and to the parties, but outdated and unconstitutional state laws have jeopardized that relationship. In the Troxell versus Granville case, Justice O'Connor pointed out the difficulty of describing the average American family. That observation was certainly relevant at the time, but seems almost quaint today because in the past 16 years, things have changed even more than they did in the previous century prior to Troxell versus Granville. The unifying principle, however, since Troxell and in this state's cases and in the U.S. Supreme Court's cases in family law, is that courts attempt to accomplish two goals. Number one, they attempt to protect the family autonomy, which means the intent of the members of the family and their conscious decision-making about what their family structure is going to look like, who will be part of that family structure, and how they will raise their children, and so on. The other unifying principle is the best interests of children. And in Arizona, that's the unifying principle throughout Title 25 and certainly underpins Title 8 as well. The children's best interests are paramount. The court is required to construe Title 25 as laid out in 25-103 in a way that's consistent with the children's best interests and also in a way that is that promotes a two-parent family structure, because the legislature has determined, correctly in my opinion, that children raised by two parents have a greater likelihood of success in the world.
Well, counsel, as I understand your argument, one of the grounds for your argument is that had Arizona law allowed it at the time, the evidence is undisputed that both parties would have adopted the children rather than just one party. Arizona law only allowed one of them to adopt, so they chose one. And what you're arguing is that since that law has now been, since the premise of that law has been held to be unconstitutional in Obergefell and other cases, we should go back and fix it. Are there any cases across the country where Obergefell has been held to have that effect?
Well, we don't have to go far, Your Honor. In Division 2, I think they beat us to the polls a bit in the McLaughlin case, where they addressed essentially this exact issue. The McLaughlin case, which we cited as supplemental authority, was an artificial insemination case in which two married spouses bore a child through artificial insemination, and under Arizona law at the time, only one was a legal parent because she was the one who bore the child, and they did not both appear on the child's birth certificate. But they did have an agreement that they would co-parent the child together, and their intent was paramount in the court's decision in McLaughlin. in determining that the non-biological parent was a legal parent. They accomplished that by applying the marital presumption, which, according to Obergefell and the 14th Amendment, needs to be applied gender neutrally in order to be consistent with the federal Constitution. In this case, we have very similar circumstances. It almost sounds as though I'm reading the McLaughlin case when I describe it. These parties were married, their marriage was valid in Iowa, and the trial court in this matter has determined that the court will retroactively recognize their marriage back to the original date. They adopted 4 children during their marriage, and if we take the marital presumption seriously and ARS 8-117A seriously, that means the children should be treated as though they were born in lawful wedlock to Tanya, who appears on the birth certificates and is on the adoption certificates, but she was married to Susan at the time, and that means there's a rebuttable presumption that Susan is the other legal parent. And if we follow the McLaughlin analysis,
but
where
even in McLaughlin, the Division II Court of Appeals acknowledged, specifically at footnote 6, that the adoption process is not comparable to the presumptive parenthood that you find in marriage under 25-814?
Well, there are 2 issues with that, Your Honor. I think that the purpose of that footnote is to address the sword and shield issue that came up in that case. The biological mother attempted to use adoption as a shield against the claim that her spouse should be the other parent to the child. In so doing, she attempted to argue that if her spouse was to be a parent, she should have petitioned to adopt the child after Obergefell, which, just like in this case, that couldn't happen because the parties had already separated, and the only way a second parent adoption can occur is by consent of the existing parent. So the court did not allow her to use the fact of non-adoption as a shield against the claim. The other concern is I don't think that construing the laws that way is consistent with this court's decision in Sheets versus Meads last year, which tells us that ARS 8117A needs to be construed extremely literally. If a child is adopted to a married person, if the child is adopted, the child should be treated as though born in lawful wedlock. If a single person adopts, that affords the child protections that the child would have had they been born to 2 parents. But in the case of a person who singly adopts but is married at the time, Sheets versus Meads tells us that 8117A still needs to mean something, and that's that the marital presumption, which is rebuttable, needs to apply. If the court finds that the parties had no intent to adopt and raise the children together, then the court could find that there's only one legal parent.
Don't we use the presumption of 814 when there's a contest as to who the second parent is? And that's not what we have in this adoption situation. The question isn't who's the second parent. The question is there a second parent?
Well, I think that it's undisputed on the record below that there is a second parent, at least psychologically. The parties intended to raise the children together. The children don't know anything other than 2 parents. What we have is an unconstitutional harm that's being proliferated and perpetuated because Arizona did not allow these parties to adopt together. And again, it's undisputed on the record below, and Judge Cohen's made the finding that these parties would have jointly adopted had they been allowed to do so. So I think the marital presumption does need to apply, and the court is obligated to correct the constitutional harm by whatever reasonable means necessary, and the statutes give this court the authority to do that.
But by pretending she adopted?
By issuing a nunc-pro-tunc order, Your Honor, saying that had the parties been able to adopt together, but for the unconstitutional law that prohibited them from doing so, they would have, and therefore they'll be treated as though they did.
But aren't nunc-pro-tunc orders primarily limited to correcting the record where there is an error?
I don't know that it's necessarily limited to a procedural error, but certainly there was an error in this case because the Constitution and Obergefell say that there was.
But you've cited no authority with respect to the application of nunc-pro-tunc order. I mean, a nunc-pro-tunc order, isn't that generally utilized that if there is an order that has some discrepancy as compared to what was on the official record, that then the court can go back and modify the order to reflect the correct or the accuracy of what was actually issued or ordered?
Well, perhaps nunc-pro-tunc is not the correct name of the remedy, but I do think the court is obligated to make a meaningful correction of the constitutional harm, and Obergefell says as much.
Well, doesn't Obergefell state quite plainly that it only applies to two situations? You know, whether or not the 14th Amendment requires states to license same-sex marriages, and whether or not the state must recognize same-sex marriages that were performed in another state.
Well, this is an issue that was raised in McLaughlin, Your Honor, and the court said that in light of Obergefell, the statutes must be applied and interpreted in a gender-neutral manner so that same-sex couples' fundamental marital rights are not restricted, and they are afforded the same benefits of marriage as heterosexual couples and on the same terms. That language is important. On the same terms means that they should be treated the same way as a heterosexual couple would be. In a heterosexual couple, the marital presumption clearly applies. And it's not purely biologically related. It can apply in other circumstances as well.
But where a heterosexual couple, where one adopted the child, the other one wouldn't be a parent. One non-adopting heterosexual.
Well, I believe we argued in the briefs, Your Honor, and I think it's true that if the parties intended for one spouse to singly adopt, then that would be reflected in their adoption home studies. And there's at least this analysis that the court can undergo where did the parties intend to adopt together and jointly raise this child or not? In our case...
So it wouldn't be, under your argument, it wouldn't be that any time one of a married couple adopts, both do, you would have to look at the intent of the parties as reflected in the documents at the time.
Yes, Judge. It's a rebuttable presumption, and in the case that's before the court today, it's not disputed on the record below, and the trial court's made that finding. But similar to the McLaughlin analysis and the test that's proposed there would be a rebuttable presumption that if the parties intended to jointly adopt and raise the children together, then the marital presumption applies. And the court would also look at whether another party is attempting to or has stepped forward to provide support for the children, which is consistent with 25103, that children should have the support of both parents where possible. In this case, there is no such other party, and I don't know that in an adoption case there ever could be. We're talking about a single legal parent who adopted, who has one spouse at the time of the adoptions. So the presumption is certainly rebuttable. The McLaughlin court has already laid out what that would look like for the court, and has also laid out the equitable estoppel grounds for how a party may be prevented from rebutting that presumption. So all the analysis is there. All this court needs to do is apply the same rule that McLaughlin adopted. If the court chooses not to do that, I think we have a real problem, because obviously we have a division split, but we also go into the territory of these children only being subject to visitation orders under 25409C.
Well, now, with regard to McLaughlin again, now, is the basis of Division II's opinion, is it that we have to interpret the paternity statute because of Obergefell to apply in the situation in that case? It has to be interpreted that way.
Yes, Judge.
Now, the language of the statute clearly applies to a presumption of paternity, of fatherhood, right? Now, isn't the doctrine, now I take it the doctrine is that we're supposed to interpret that statute in a way to make it constitutional? Is that what we're talking about here?
That was the basis for the McLaughlin decision.
Right.
The court needs to construe the statute constitutionally.
But isn't the limitation on that doctrine that you can't rewrite a statute in a way that contradicts what the statute says in order to make it constitutional? And it clearly refers to a man and paternity. So it has to be rewritten to apply it the way Division II wants to apply it.
So Arizona statutes all apply the word man or male in the neutral gender.
But it's clearly directed at determining paternity.
Well, more importantly, Judge...
Question.
I'm sorry.
We generally know who the mother is, but it's directed at determining paternity.
Well, only one subsection of 25814A relates to biological paternity, and that's subsection 2, that genetic testing affirms at least a 95% probability of paternity, then a man is presumed to be the father of a child. But the other subsections don't rely on biology. They rely on the timing of when the marriage occurred, whether the birth certificate is signed by both parents for a child born out of wedlock, and whether a notarized or witness statement is signed by both parents acknowledging paternity. None of those are...
The legislature intended those other subsections as being aids in determining who the father is?
Well, I think this falls back, Your Honor, on the Troxel versus Granville observation that families aren't just a nuclear family with one man, one woman.
I'm not arguing about that. I'm arguing what the legislature wrote and enacted, and the limitation on the idea that we can reinterpret a statute to make it constitutional is we can't rewrite it in a way that contradicts what the legislature did.
Well, I don't think it would contradict...
You can adopt a reasonable interpretation of ambiguous language, and if you have a choice, adopt an interpretation that makes it permissible under the Constitution.
Well, again, I don't think the legislature wrote the statute so that biology was the only purpose here. And the court is obligated to apply it gender neutrally under Obergefell in the 14th Amendment. And in this court...
There's a possibility that the statute is just unconstitutional, right?
That may be the case, but the court is obligated to attempt to read the statute in a way that is constitutional and can do so by applying the presumption gender neutrally with a rebuttable presumption based on intent. And if it's all right with the court, I'd like to reserve the remaining time for rebuttal.
Sure, thanks.
May it please the court, my name is Keith Berkshire, attorney for the appellee, Tanya Doty. I know McLaughlin very well because I'm filing the petition for review on it tomorrow. I argued it at Division 2 2 months ago. McLaughlin is very clear. It's an application of 814A. That was the entirety of the argument in McLaughlin, is that the paternity presumption must be applied gender neutrally. Our argument was that it didn't have to be, that there's a Supreme Court case called Nguyen that talks about paternity and maternity are different things. That being said, even if McLaughlin is the law, which currently it is, for out of Division 2, McLaughlin is an 814A case. Their position to apply 814A is a rewrite of 814A. Under 814A1, it says if the father is married to the mother at the time of birth. It does not say at the time of birth, comma, or adoption. It says at the time of birth. 814A2 is there a DNA test? That clearly doesn't apply as well. 814A3 is the other parent on the birth certificate? That doesn't apply as well. 814A4 is there a signed and notarized statement acknowledging paternity that substantially complies with the acknowledgement of paternity in another part of Title 25? That doesn't apply either. I do want to state that the record is not clear that there was consent. My client on trial transcript 3, page 9, says that petitioner, appellant, did not request to adopt them jointly prior to her filing for divorce. That was the testimony in this oral argument, as the court called it, this very brief oral argument in October.
You say consent. Do you mean to say that the evidence didn't support the conclusion that had the parties been able to adopt jointly at the time they would have?
Correct. My client contested that there was not a joint intent to adopt. We understand that that's Judge Cohen's finding and so forth, but this is very limited testimony. One of the things that appellant points out repeatedly in their petition is a quote out of the petition for adoption. It says, and they quote it multiple times in their opening and reply brief, that petitioner, meaning my client in the adoption, intends to adopt the children as a single parent. I mean, their quote says she's adopting them as a single parent, not a single parent but for if I could have, that being the issue. So McLaughlin is a very, very narrow case. It applies, even if I disagree with it, what the ruling of that is 814A, and that is it. There's no retroactive application to other areas. It is 814A, and and they read it gender neutrally, which currently is somewhat the trend on that. But it doesn't apply in no part to adoptions. As Judge Cohen stated during, I can't remember if it's in the minute entry or not, but it was definitely in the transcript. She called down and talked to commissioners, and they say married people single-parent adopt all the time. And there's no such intent presumption here. One of the cases that we cite to is appellant basically has two different arguments here. It's some sort of retroactive nunc-pro-tunc, or whatever you want to call it, adoption, or that Arizona should adopt the de facto parenting standard, which is basically the standard under the Uniform Parentage Act, which Arizona has never adopted. The adoption, Arizona is, every case for adoption, and I could cite multiple, including Arizona Supreme Court cases, that adoption is strictly construed, adoption is strictly construed, adoption is strictly construed. That, I think, disposes of the adoption argument. The de facto parent argument, this court addressed in Egan. And frankly, the facts of Egan, if you really wanted to look at them in 2009, were a much more, I guess you'd call it, egregious set of facts if you were on appellant's side. 17-year same-sex marriage, or 17-year same-sex relationship, agreed to artificial insemination during their relationship, raised the kid together for 7 years. And even in that case, this court found that we don't apply de facto parenting. Now, while appellant says that that's dicta out of Egan, paragraph 25 and 29 go farther in Egan and discuss that this court found that it's clear that the intent of the legislature when they adopted what was then 25415, which is now 25409, that the intent was to create no common law, that the legislature, this court states that the legislature clearly intended to create no common law or leave open any common law theories of equitable parentage. So that, to me, disposes of the equitable parentage, de facto parenting argument. Now, I would also remind this court, while we didn't cite it in our brief, this court just ruled in January in a case called Goodman v. Forson and upheld all of the theories out of Egan. Judge Schwan wrote the opinion, and I believe it was in January this year, that parents have more rights. There is no de facto, and reaffirmed all of the key provisions out of Egan. Arizona has repeatedly, every single opinion that has come out of Arizona on 25409, the new combined version, or the old version when it was just grandparents' rights, and 25415 being in loco, every time this court and the Supreme Court in Finnick have stated that this is purely statutory. We have no argument about policy in this arena. The Supreme Court in Finnick, if this court remembers, Supreme Court in Finnick, at that time, there was no in loco parentis statute. There was only grandparents' rights. The Supreme Court in Finnick said flat out in the end of it, we think that's, for lack of better words, crazy. But that's not our job. It's the job of the legislature, even though we think there's other relationships that matter and that should be involved with the children, that is solely up to the legislature. And guess what happened after Finnick? The legislature added 25415 and changed it. But every time that this has gone up, that there has been a holding that the in loco parentis and the de facto, it is a purely legislative matter subject to narrow construction by that. When this court, just in January in the Goodman case, they set out even the new standard, some would call a new standard, for looking at these in loco parentis cases. And when Judge Schwan wrote the opinion on this, it was that it isn't up to the court to determine that there's a better result. They defer to the parent unless there is proof of a significant detriment to the child that they're due to their decision, due to the parent's decision. Arizona has we have two places. We have a very clear statutory definition of parent. In 25404, legal parent is specifically defined as biological or adopted parents whose rights have not been terminated. In 602E, a statute that's never been interpreted, but what the Parents' Bill of Rights, which was adopted in 2010, again, the natural or adoptive legal parent is defined as the natural or adoptive parent or legal guardian of a child. We don't meet that here. They can't point to any cases that say Obergefell retroactively changes everything. If you had intent at one point, their argument could be extended to if same-sex couple who weren't married or didn't go through a legal marriage in another state, they can have intent. That the argument could be that those parties have rights. It could be argued to boyfriend, girlfriend. Adding intent when there's no statutory justification for intent it's frankly a scary proposition.
Well, it's a simpler, easier argument than making the one that you posit, because they were married. So intent to be committed to each other is
I
not a
understand
question.
that.
Yeah.
They can, the argument of that during marriage. Well, you've also then got the argument, well, we intended to be married. The same argument applies to their marriage, but for Obergefell, their argument is that we didn't adopt and we didn't file any case against the state. This is my ripeness argument. We didn't file, despite thinking that we were having our rights constitutionally violated. We did nothing to challenge the adoption. When they went in, they could have filled out the petition together, challenged it, got denied, and taken it up, kind of like Mr. Obergefell did. My ripeness issue is that they never did anything. They waited around till Obergefell got decided and say, hey, wait, 6 years ago I had a constitutional violation. They cite to a case called Williams that for this proposition that their argument is ripe. Williams was, you didn't have to go get violated because you knew the statute was against you and you were going to have this, you didn't need an injury in fact. But what Williams did is then they sued for a DEC action saying this is a constitutional violation. They've still never even said that there was a constitutional violation under this statute in this case. In fact, they didn't even, in their petition, their amended petition for divorce, they didn't even allege this retroactive adoption theory.
Well, they didn't because, well, who knows why they didn't. But what before the dissolution, Obergefell came after the dissolution, correct? I'm trying to remember the timing.
After the filing?
Right.
I believe so. I mean, Obergefell was June 28, 2015,
okay.
So.
Which of the, but there were prior cases.
Arizona had, obviously, out of division, out of the Ninth Circuit, and when Tom Horn declared it in October.
Is your argument that at that time they should have gone in right after the Ninth Circuit case issue?
My argument is that they could have done what Mr. Obergefell did and file at the time saying the statute under Title VIII was unconstitutional when they jointly tried to adopt and were denied. They could have filed at that point. That's how laws change. That's how Obergefell changed the laws. He tried to get a marriage license and denied, and then sued the state. They could have done the same thing. Them not doing this, again, they've still never done it, was their violation. I mean, they've waived it over this period of time. It's been 4 or 5 years at this point since the alleged violation, and they've never done an actual constitutional claim against it. But I think I get the ripeness issues kind of over here, but at the end of the day, adoption, I mean, Obergefell definitely does not say anything to the extent of going back and potentially, fixing any potential wrong based on this theory of intent. Obergefell states, as Judge Gertler states, which is that you have to recognize same-sex marriages from other states, and you have to allow them in your state. Now, admittedly, Obergefell does discuss that one of the rights that has potentially been denied due to the lack of allowing same-sex marriages is the lack of the ability to jointly adopt. But it's a far stretch to retroactively make all these correct. One of the cases we cite, in our case, this Estate of Layton case out of New York, which is a post-Obergefell case where somebody came in and argued the same thing. But for the ban on gay marriage, we would have gotten married. And in that case, the court said, yeah, but you didn't try, you didn't do anything. We can't retroactively make all these changes. And, I mean, you think of even the potential arguments here, the expansion of this. I mean, right now, across the country, what's going on in these cases is people suing, and I'm just speaking on CLE on this topic next Friday, the issue of people going through and stating that domestic partnerships are the valid marriage that they have to retroactively recognize too. And the states are all over on that. The intent in a commitment ceremony, and the states are all over on that. What this really gets down to, frankly, is the de facto parenting theory. Other states have recognized de facto parenting for 30 years. Arizona has not. and never has in any way. There was a case that came out the day before we argued McLaughlin in Division 2 out of the New York Supreme Court, where they used the same intent theory to not only recognize, New York has recognized that in a same-sex relationship with a domestic partnership or a marriage, that artificial insemination, if you had the intent with the other spouse, they were going to recognize equal parentage under this de facto theory. The day before McLaughlin was argued on August 30th, New York extended that. You didn't even have to be married or even have a domestic partnership or anything else. It's just if you had intent. So other states can do that, but that's their common law. Arizona does not have that common law, and Arizona does not, and no state has found, and definitely not the Supreme Court, has ever found that not having that common law is a violation of the Constitution, including post Obergefell. So the issue here to us is very narrow statutory construction. There isn't an adoption. There was never a lawsuit about the adoption that went up to the court or anybody else got joined with any of the other cases that then this court could say, hey, your rights were violated by not allowing the adoption, therefore you can have one. So that's the first part. The second part is an attempt to apply the paternity presumption due to birth to an adoption, which is a rewriting of the statute, which again, I mean, the basic, obviously, concepts of statutory interpretation, or you read it narrowly. At no point in 814A does it say a child born or adopted during marriage. Frankly, the Sheets case, which actually is another one of mine, was that was the issue, was that the trial judge in Sheets added in the minute entry that since the child was adopted during marriage, that statute applies. That's what this court overturned this time last year, saying, no, it does not. You do not get to rewrite statutes. It's literally exactly what the judge did in Sheets. Now, again, Sheets wasn't married, but they added words to the statute, which is their position, born or adopted during marriage. They want the or adopted added.
Irrespective of the difference between 2514 and 8117A, didn't Division 2 still essentially retroactively apply Obergefell? I mean, in McLaughlin, you had a situation where they had married in California in 2008. The artificial insemination occurred in 2010. Birth happens in June 2011. Arizona doesn't recognize same-sex marriage. You now have an issue, vis-a-vis the same-sex couple, and the Court of Appeals still went back and said, hey, at the time of birth, they were married at vis-a-vis a California decree.
Part of my petition for review is frankly that argument that at the time, one of the arguments is they weren't legally married. So that retroactive argument. However, at least Obergefell can argue that. But Obergefell can argue that. You must recognize the legal marriage for someone else. They were at least legally married somewhere else. In McLaughlin, they were legally married at the time. Not in Arizona, but they were legally married. There's no legal adoption here in another state that Arizona's not recognizing. They were legally married in another state. So, but again, they had that recognition. There's no such recognition here. They want to rely on the intent to. So in McLaughlin, if there wouldn't have been a actual marriage, would they have applied this with the intent? I don't think so, because that's exactly what the Leighton case is. You don't get to retroactively change that. And again, reading Obergefell even very narrowly, it says you must recognize legal marriages of other states. So they had one. And those constitutional claims have typically been recognized retroactively to, quote, fix wrongs. But they did at least have something that they don't have here. And I'm glad Judge Gertler brought up the footnote, because that was in my notes to bring up, that this is a very different situation than adoption. And adoption has always been held to be very, very narrow. And the court in McLaughlin does address that this is a different situation, because the paternity cases, all the stuff that's cited by Division 2, Band v. Quigley, and these other types of cases, talk about that unit at birth and whether not knowing or knowing, down the road is the issue. And that's the case they cite. And in the footnote, they again, say, aside from the fact that adoption E was not a viable process, the adoption process is not comparable to the presumptive parenthood based on marriage. I mean, that's a pretty striking statement because, frankly, appellant just doesn't have a statute that applies. I mean, that's the end of the day. There's nothing that actually says that they have a case here from the standpoint of any Arizona statute. There's under 8117, if you look back at the history of 8117, when 8117 was put into place, it was so that there were laws about that if you were born out of wedlock, different laws applied. I mean, 8117 is a very old statute in Arizona because kids born out of wedlock could be treated differently. So that's why that was put in there. It never created an issue of single versus double parent adoptions or some presumption based on that. And unless there's any other questions, that's all I have.
Thank you.
Thank you, judges. I'd like to speak briefly about the footnote in McLaughlin again, and then I'll move on to the Uniform Parenting Act issue. As Keith just pointed out, presumptive parenthood based on marriage is not comparable to adoptions. That's what McLaughlin said. But we're not talking about presumptive parenthood based on... The point is, the presumptive parenthood here does not arise from a biological relationship. And I think what McLaughlin was getting at was if two people were together but not married and one of them had a child by artificial insemination, the marital presumption clearly would not apply. If one person adopted and was not married at the time, then clearly the marital presumption does not apply to any significant other they may have. But what we have here, just like in McLaughlin, is a valid marriage in another state and a birth event that occurred. 8117 says adoption treats the child as though born in lawful wedlock. A birth event that occurred during the marriage. The marital presumption must apply. It must apply gender neutrally or else it's unconstitutional. Obergefell tells us that, and the McLaughlin court treated it that way. And this court in Sheets versus Meade last year said that we must strictly construe the adoption statutes. Appellee can't have it both ways, that Sheets sometimes treats the adopted child as though born into lawful wedlock and sometimes doesn't. This was a valid marriage. The children were adopted during that marriage. They were born according to law. They were born to one of the parties. The marital presumption must apply. I'm going to move on also to the de facto parent issue. We pointed out in the briefs that in Egan, the rejection of de facto parenthood was dictum. It also took place in 2009, and we know that family law jurisprudence has changed tremendously since then. Even since last year, post-Obergefell, things just don't look the same. There's no case or statute that says there is no de facto parentage in Arizona. But the statutes do say that the court should construe Title 25 to promote two-parent families and the children's best interests. The legislature acknowledged that the court won't always be able to apply the statutes word for word in a way that's consistent with promoting those families and the children's best interests. We're asking the court to find in that gray area that there is space for de facto parenthood. If not, then the court is treating these adopted children who have no access ever to a third-party visitation petition as though they have only one parent when they psychologically have two parents. The court can accomplish that through a de facto parenthood finding. The other issue I want to raise is under 25401, the legal parent definition, the paternity presumption is mentioned. So there are three definitions of a legal parent. One is a biological parent, two is an adopted a child adopted to a parent, and then third is a person to whom the marital presumption applies. Lastly, this is not a ripeness case. We cited Lambert versus Williams for the prospect that a futile gesture is not necessary for someone to effectuate their constitutional rights. And really, it's a little naive to suggest that Susan hasn't requested relief from the court because she did so at the first opportunity it was realistically possible for her to do that. By the time Sevchik versus Sandoval came down and Tom Horn began allowing second parent adoptions and then Obergefell followed, the parties were already separated. She could not second parent adopt without consent. Her petition would have been summarily denied. Instead, when the divorce occurred and she realized that she was going to lose her children, She requested relief from the court, and that's why we're here today. So I think it's just, I don't think this is a ripeness case. I think she's clearly requested the relief in the form and at the time that she was required to do so. The court absolutely has jurisdiction to consider these issues and needs to consider the best interests of these children above all else. Without relief, without meaningful constitutional relief, the children will be left without one of their parents, and they will be left without that parent on the basis of the Arizona Constitution and statutes, which are clearly unconstitutional, and the harm that's propagated from those. If there are any further questions, I'd be happy to answer them. Otherwise, I think I'm finished.
Thank you.
Thank you.
Thank you to you both for your fine argument. We're grateful for your briefs as well. We'll take the matter under advisement and issue a decision in due course. Now we stand adjourned.